guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. Big news out of Carroll County today in the Delphi case. Just when we thought last week's bombshell was big enough, the hits keep coming. And it's like, I don't know what to think. The remaining attorney left defending the alleged Delphi murder suspect, Richard Allen, is asking that the judge, which is Judge Gull, overseeing the case, that she be thrown out of the case, claiming that she ambushed and coerced the defense team to quit. So he's saying that it's because of the judge that they were forced to quit. Now, this is coming from attorney Bradley Rozzi, or Rozzi. I keep saying Rozzi, and I don't know if I'm going to be able to say his name correctly. Hopefully I'll get it right by the time we get to a trial, because it looks like he is wanting to stick around. He's currently the sole defense counsel that's still representing Richard Allen in the, of course, the highly publicized double murder trial of Abby and Libby. Now, he filed several motions today in Carroll County arguing why he believes that he should be able to continue to represent Richard Allen and that Judge Gull should be recused from the case. Now, those who are not aware, which I'm sure you are by now, Richard Allen is charged with the 2 counts of murder in the February 2017 deaths of Abby Williams and Libby German near the Monon High Bridge in Delphi, Indiana. And he has been represented by Rozzi, and up until last week, Baldwin was the other attorney on the case since November of last year. Now, we did hear that Baldwin put in a oral request to be recused from the case, but the judge was stating during that 3-minute, not even 3-minute, a court hearing, I don't even know if we can call it a hearing, I guess it was just a minor appointment last week, that attorney Andrew Baldwin had decided to withdraw from the case. He had come to her before they were supposed to have the hearing and asked to be recused. And then she informed everyone, and of course that included the media, because everyone heard it about 30 or so minutes later on a delay, that she also stated that Rozzi was going to be submitting also a written recusal from the case, and meaning that both defense attorneys for Richard Allen were going to voluntarily withdraw from the case, and she would have to get 2 new defense attorneys for Richard Allen. Thus, no further court proceedings could happen until this was done. Now we're looking at this week, which is I think about a week later. Rozzi is stating that he was ambushed by Judge Gull during a conference in her chambers in Fort Wayne last week with allegations of gross negligence, which forced his partner in the case, Baldwin, to resign and ordering him to do the same. He filed a lot of filings today. I'm going to go through what I have right now, but he's pushing back and asking her to leave this case, and he's stating that he wants to stay on representing Richard Allen. So, like I said, if we thought it wasn't crazy enough last week with what we thought they both were going to leave the case, apparently, Rozzi did not want to leave the case, and he's fighting back. He's fighting back, stating that I don't want to leave. I want to continue to represent Richard Allen. So let me pull up the filings here. tell you, this case has never been a typical case, and I don't think it's going to ever be. So this is a motion for continuance that he filed today in the case, and let me go through that here. Comes now the defendant, Richard M. Allen, by counsel Bradley A. Rozzi, and respectfully request that this court continue the October 31st, 2023 hearing set in this cause. In support of said motion, defendant Allen states as follows. 1. Counsel for defendant Allen is unable to locate any specific order wherein the court scheduled the initial October 31st, 2023 hearing date, nor is there any order which articulates exactly what matters were to be addressed and how much time was to be set aside to address said matters. Now again, these are just a few filings, so I guess I'm not reading them in order, but this is his continuance filing that he's arguing about the October 31st hearing, which obviously means, like I said, he's like, I'm not going to leave this case. He doesn't want to leave. Number 2, however, counsel does acknowledge that there have been discussions between the court and lawyers regarding the October 31st, 2023 hearing date and the possibility of the court conducting a hearing on the pending suppression motions filed by defendant Allen. On September 18th, 2023, defendant Allen filed his motion for Frank's hearing. The court has yet to issue a ruling on said motion. 4. On October 2nd, 2023, defendant Allen filed his supplemental motion for Frank's hearing. The court has yet to issue a ruling on said supplemental motion. Number 5. On October 3rd, 2023, defendant Allen filed an additional Frank's notice. The court has yet to issue a ruling on the issues raised in said notice. Number 6. On or about October 14th, 2023, this court ordered defendant Allen's defense team to cease all work on defendant Allen's behalf and therein prohibited counsel from engaging in preparation for the October 31st, 2023 hearing or any other matters associated with this case. So it sounds like Rozzi is stating that he was told by the court, by the judge, he and Baldwin, who was on the case, that they were no longer allowed to continue engaging in the preparations. This is what he's alleging in this filing. On October 19th, 2023, the court engaged in actions which resulted in... Number 7, on October 19th, 2023, the court engaged in actions which resulted in the court ordering the oral withdrawal of attorney Baldwin from this case. Number 8, attorney Rozzi remains the only active attorney of record in this case. Number 9, on or about October 25th, 2023, attorney Rozzi filed a motion to disqualify. Attorney Rozzi believes that a full and final disposition on the motion to disqualify should take precedent over the issuance of any rulings on the Frank's motions, the disposition of the pending suppression matters, and any other matters of substance which are currently before the court. Further, defendant Allen believes that any suppression hearing in this cause will require more than 1 day of the court's time and will require the appearance of witnesses, which most certainly cannot be secured between now and October 31st, 2023. And number 11, it is for those reasons that defendant Allen requests that the hearing on October 31st, 2023 be continued to a date and time following a full and final disposition of the motion to disqualify filed on October 25th, 2023, and for all other just and proper relief in the premises. And this is, of course, signed by Bradley A. Rozzi. Now, this is the precipice Precipite, I'm probably saying that wrong, for transcript. Comes now the defendant Richard M. Allen by counsel Bradley A. Rozzi. The precipice for transcript in the above captioned matter. Said transcript shall in chamber two-part hearing held on October 19th of 2023 in front of Judge Francis S. Gull, including the original recording and transcript thereof. So there was an in chamber hearing with the judge and Baldwin and Rozzi. He wants that transcript. So that's what this particular filing is for. Now here is the big one. This is the motion to disqualify. This is the big one that he is trying to get Judge Gull out. Comes now the accused by counsel and pursuant to Rule 2.11 of the Indiana Code of Judicial Conduct and Rules 12B and D of the Indiana Rules of Criminal Procedure, respectfully and moves for recusal of and change of judge from Judge Francis C. Gull. Number 1, Rule 2.11 of the Indiana Code of Judicial Conduct requires a judge to disqualify him or herself when the judge's impartiality might reasonably be questioned. Such is the case in this cause of action for the reasons described below. Number 2, the comments to Rule 2.11 provide additional guidance. Under this rule, a judge is disqualified whenever the judge's impartiality might reasonably be questioned, regardless of whether any of the specific provisions of the paragraphs A1 through 6 apply. In the many jurisdictions, the term recusal is used interchangeably with the term disqualification. A judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. A judge should disclose on the record information that the judge believes the parties or their lawyers might reasonably consider relevant to a possible motion for disqualification, even if the judge believes there is no basis for disqualification. Number 3, Judge Gull has removed and concealed or allowed to be removed by the clerk of Carroll County defense pleadings from the chronological case summary in violation of the Indiana Supreme Court's administrative rules. Those pleadings include Frank's motion filed 9/18/2023, Frank's memorandum filed 9/18/2023, 3 affidavits, Warden Gallipo, Sergeant Jones, Sergeant Robinson, filed 10/10/2023, and the affidavit of the leaker, Mitch Westerman. Judge Gull has not removed or hidden any state filings. So yeah, these are what they're accusing Judge Gull of doing. Number 4, Indiana access to court records. Rule 2A provides in pertinent part, all persons have access to court records as provided in this rule, and that certain persons have greater access to court records. The commentary to ACR Rule 2A is that all persons, including members of the general public, the media, and commercial and non-commercial entities, are entitled to the same basic level of access to court records. And ACR Rule 4 provides that a court record is accessible to the public except as provided in Rule 5. ACR Rule 5A provides that certain entire cases shall be excluded from public access without notice of exclusion, but this entire case has not been declared confidential by statute or rule and meets none of the other criteria laid out in ACR Rule 5A. ACR Rule 5B provides the process for excluding individual case records. However, none of the 13 listed grounds for excluding public access to the records secreted from the docket in this case apply to the above referenced documents, which had either disappeared from the CCS or are inaccessible to the public, nor were the documents filed using the procedures required by ACR Rule 5B, i.e. filing on green paper or filing electronically as a confidential document along with an ACR from identifying the specific grounds upon which exclusion is based. By secreting pleadings from the docket without following the access to court records rules, Judge Gull has allowed violations of public access. Because those acts have only shielded documents from the defendant, these actions clearly demonstrate a lack of impartiality and fairness in violation of Judicial Rule 1.1, compliance with the law, and Rule 2.2, impartiality and fairness. Number 5, on October 12, 2023, Judge Gull instructed appointed counsel to cease work on Mr. Allen's case, which interfered with the attorney-client relationship and prejudiced the accused by denying him the timely, effective representation guaranteed him by the state and federal constitutions. On October 19, 2023, Judge Gull conducted critical stage proceedings in chambers outside the presence of the accused, even though she had ordered him transported and he was available. She then did the same after placing his attorneys in an ethical dilemma and again creating a public record outside of the presence of the accused. This ignored clear precedent. So yeah, this is going into last week where Richard Allen was transported to the court, but she met with the attorneys before that hearing and then just sent him back to the jail. Number 7, on October 19th, 2023, Judge Gull ambushed appointed counsel with a planned Hobson's choice designed to coerce withdrawals. The choice presented was to suffer a public shaming and be removed from the case or to voluntarily withdraw. Despite defensive counsel requesting clarification as to the topics and her motions to be addressed at the October 19th hearing, she gave the defense counsel no notice of her plan to force withdrawals or to remove them, thus denying counsel the opportunity to adequately refute her accusations. So I guess what we all thought, she was surprised that they were withdrawing? Well, maybe she's a good actress, huh? Because it sounds like that's not the case according to Rozzi's filings here. Number 8, the same day Judge Gull had a prepared statement that she threatened to read to the public, alleging defense counsel was grossly negligent in their representation of defendant Allen. Judge Gull's complaint was more about not having control over counsel rather than any legitimate concerns that counsel had engaged in conduct that compromised Richard Allen's defense. A general summary of Judge Gull's complaints are as follows. A press release, generic in substance, was issued by the defense in November 2022 before the court's gag order and only after repeated press conferences by the prosecution. Allen's response: the intent was only to level the playing field. This was well within the obligations of defense counsel by established guidelines. She never expressed any concerns over the multiple press conferences by the prosecution. B, the 2 motions filed by the defense, one of which addressed the health and safety of defendant Allen, and the second of which addressed the immediate transfer of the accused due to the not-so-coincidental and undisputed facts that the individuals engaging in Norse paganistic practices may not only murdered 2 girls, but that they were also escorting defendant Allen around the prison at the same time his health was in rapid decline. Allen's response: the court had previously ordered the accused transferred to a state prison at the request of the Carroll County Sheriff. His mental and physical health began an immediate decline. Prison guards in his area had Odinistic emblems on their uniforms, which endangered their client after the Odinistic connections were exposed. The defense had video of the patches and the guards admitted they wore them. The defense had previously noted a connection between the murders and Odinism. The patches have since been removed. Mr. Rozzi cited instances of abuse. Those filings were within the obligation established guidelines imposed for effective representation. So they have video of the patches? I would like to see the media evidence of that, because remember, they alleged that in that huge filing about, the whole Odinism cult, that they filed, and I still don't know what to think of it, to be honest with you. C. Mr. Baldwin had drafted an email to co-counsel but sent it to the wrong person due to self-populating in the electronic mail. Allen's response. This was an accident that happens routinely to most people. The intended recipient, attorney Bradley Rozzi, and the unintended recipient share the same first letters of their first names. The email attachment contained no substantive information, just a bare-bones outline of a tiny portion of the discovery received by the defense in this case. D. The court alleged that Mr. Baldwin put improper statements in his Frank's memorandum. Not false or misleading statements, just improper in her opinion. Allen's response. The court had disdain for the defense for not filing under seal, even though there was no order to do so. That memorandum was demanded by the prosecution before there could be a Frank's hearing. It is an impressive piece of legal writing and has been lauded by expert defense counsel across the nation. It again was required by applicable guidelines. E. That Mr. Rozzi has filed a tort claim notice to preserve the rights of his client. The court opined that this action amounted to gross negligence. Allen's response. The filing of the notice was intended to preserve the rights of a man who was shuttled off to one of the most secure detention units in the state. Locked up and isolated with only a tablet, which was often dysfunctional, to communicate with the outside world. Allen had no ability to speak with his wife in private, as his phone calls were all being recorded. Allen's own attorneys were required to make advance reservations to visit him at the prison. It is entirely impractical that Allen would have had the means to prepare his own tort claim notice and or secure private counsel to do so. But aren't all phone calls recorded, period, in a jail prison? So I'm not sure that particular part really makes a difference. Now, as far as speaking to his attorneys, yeah, that should be private. F. Mr. Baldwin had hired a lawyer to represent him in this matter. Allen's response. This is what was not true. Mr. Baldwin was betrayed by a friend, and there was a subsequent related unaliving. Be careful with my words here on YouTube. As a friend and colleague, David R. Hennessy suggested he needed a lawyer to speak on his behalf, and he volunteered. No fee was arranged between the two. The court also alleged undersigned that had put volatile facts in their memorandum regarding possible sanctions or disqualification. The true facts in a criminal case are often volatile. There was no untruth. So he's saying that the whole thing that we were hearing last week, that Baldwin hired a lawyer, yeah, not really true. The dissemination leak of crime scene photographs in which neither attorney Rozzi or attorney Baldwin had knowledge of nor participated in. Allen's response. See affidavit of Mitch Westerman previously filed. 9. Guideline 1.1 of the Indiana Public Defender's Council's Performance Guidelines for Criminal Defense Representation states the paramount obligation of criminal defense counsel is to provide zealous and quality representation to their clients at all stages of the criminal process. Similar obligations are recognized by the American Bar Association, the National Legal Aid, and the Defender Association, and the National Advisory Commission on Criminal Justice Standards and Goals Rule 1.1 IRPC. 10. Everything cited by Judge Gull as concerning was either not attributable to Attorney Rozzi or excellent and ethical lawyering in the best interest of the client's defense and mental and physical well-being. 11. Throughout the pendency of this proceeding, the defense has exposed untruths by law enforcement, withholding of exculpatory evidence by the prosecutions, and discovery violations about which Judge Gull showed no concern and did nothing. The court has routinely expressed umbrage at defense counsel's representation through investigations and filings while silently abiding prosecution's discovery delays and false statements by them or their agents. 13. On October 19th, 2023, Judge Gull coerced an oral request to withdraw from attorney Rozzi that did not comply with Rule 3.8H, Indiana Rules of Trial Procedure, and further coerced an oral request from attorney Baldwin to withdraw as co-counsel in this cause. 14. Judge Gull has exhibited a lack of concern about and taken no action to protect the physical and mental health of the accused. 15. Throughout the proceedings, Judge Gull has exhibited a bias and prejudice against the accused and his attorneys in favor of the prosecution. 16. Counsel for the defendant are appointed pauper counsel, and upon appointment, judicial control and oversight of the appointed counsel is inappropriate. The court cannot and should not dictate the process of representation or impropriety curtail the representation of counsel. It is done so without notice to the defendant or his counsel, affording them an opportunity to be heard. It has also done so of its own accord without any precipitating motion or request. No due process has been afforded. 17. Rule 2.11 of the Indiana Code of Judicial Conduct requires a judge to disqualify him or herself when the judge's impartiality might reasonably be questioned. Such is the case in this cause of action for the reasons described below. 18. Rule 1.2 of the Indiana Code of Judicial Conduct states, a judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. 19. As previously stated, Judge Gull strong-armed attorneys Rozzi and Baldwin with a prepared statement that she intended to read into the record had either attorney resisted her efforts to remove them from the defense. Within minutes, Judge Gull took the bench, started the record, and informed those present and the viewing public that there existed an, quote, unexpected turn of events, unquote, with the defense team withdrawing from the case. Judge Gull further stated that these circumstances were, quote, clearly outside of our control, unquote. The only clarity offered up by these statements is that they were entirely inconsistent with her actions in chambers just minutes earlier that forced the attorneys to consider withdrawal in this matter. Those words run afoul of Rule 2.1. as they demonstrate the tribunal's lack of integrity, impartiality and toward the public, and usurp defendant Allen's right to competent legal representation. 20. Rule 2.2 of the Indiana Code of Judicial Conduct requires that a judge shall uphold and apply the law and shall perform all duties of judicial office fairly and impartially. Comment 1 to the rule states, to ensure impartiality and fairness to all parties, a judge must be objective and open-minded. 21. Rule 2.15 of the Indiana Code of Judicial Conduct in pertinent part states, B. A judge having knowledge that a lawyer has committed a violation of the rules of professional conduct that raises a substantial question regarding the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the appropriate authority. It does not indicate that any such opinion of the court allows removal of the appointed counsel without due process and against the wishes of the accused. 22. Judge Gull has violated rules 1.2, 2.2, 2.3, 2.6, 2.8, and 2.11 of the Indiana Code of Judicial Conduct. And of course, it is signed by Bradley A. Rozzi. Woo! All right. So, I think there's a couple other filings because he did file a lot today, but those are the essence. And that last one is the major essence. Obviously the first one being that he's not, that, the whole October 31st thing is like, well, we've been told to stop working on the case, and the whole proceedings that happened on October 19th, Rozzi stating, whoa, 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 that's not exactly what happened. So that request for the transcript, well, that's what he's looking for the, in chambers, because that's going to show a lot. That's going to show a lot, because, you're going to have the court reporter in there for that. But just when you think this case, has gotten crazy, we have one turn, and then it turns around and goes the other way. So, will Judge Gull be removed? I don't know. I mean, she's generally a very well-known and very renowned judge in the area. That said, I think that Rozzi, Attorney Rozzi he seems to be a very good attorney. He's put all these filings in. He's fighting for Richard Allen. And as much as we all want to, basically we want to like go after whoever it is. I mean, we want to, if he's bridge guy, okay, we want justice for these girls. That's the point. I always want to put their photos up here, because the bottom line is justice for Libby and Abby. Okay, that said, I do believe that Richard Allen's involved. My personal opinion is he's involved. Is he the only one involved? That I don't know. I think there could be one, there could be another, there could be more. And as far as this Odinistic cult stuff, I don't know. It's out there to me, but I don't know. I mean, it's a lot. I mean, stranger things have happened. But really, as much as we dislike Richard Allen, he is entitled to a fair and good defense. Period. Every single accused has that right in this country. As much as we may or may not like them, he's got that right. So I have to say, I think it's great that Rozzi is fighting for him. It sounds like Baldwin just was ready to take home his briefcase and just be like, I'm done with it. That said, a lot of crazy stuff has happened. He does bring up the whole leak. He's claiming that that's not from him or Baldwin. It's a leak from someone, I guess, who is a part of their team or knows them, and the photos got leaked. Speaking of the photos, you will never see them here on this channel. Never. I haven't seen them, and honestly, even though I'm curious, because as a follower of true crime and crime stuff, I don't want to see them. I really don't. I'm going to have that curiosity. I'm not going to lie. I have the curiosity, but at the same time, I've heard folks that have seen them say they really wish they hadn't seen them. So I would rather remember and know these girls for photos like this right here on the screen. Because that's who they were. They were young, 13 and 14-year-old girls, middle school girls. They were in the prime of their lives. I mean, they were soon going to be in high school. They were active kids, in this small town, and they decide to take a day off and go wander on a local bridge trestle that's popular, and this horrible thing happens to them. And I do believe that the Anthony Schatz account has more to do with it. So I don't think we're done with Kagan Klein. But I don't know. I mean, we're definitely not going to have a trial in January. I don't think, regardless of what's going on, January is out. There's just no way. But I don't know. I mean, it's like we were already stunned enough last week when we heard that these attorneys were withdrawing, but now one of the two is like, I don't want to leave. I didn't, I never wanted to. So, and then he's saying, well, the judge should leave. So it's dirty. This is a dirty situation, I think, in some ways, and I don't know. I mean, I continually feel bad for the families because, of Abby and Libby, because they have to sit there. They were sitting there through this, and now they're having to hear today that what the judge said in that 3 minute, on the bench, on the record, is not necessarily what happened. So, I mean, I don't know. I mean, we need a judge, I don't know what's true and what's not true. I mean, again, that's going to be something that's up to people who get paid a lot more than I do. And of course that this is what they do. I mean, you have the judicial boards and all that sort of stuff. There's experts and attorneys and other judges for that kind of stuff. But I don't know. I mean, you definitely want to have a judge up there who's fair, impartial, and just listens to the case. I mean, we just had that other judge that was sitting there texting and making fun of witnesses and stuff. And, I mean, I'm not saying that Judge Gull is a bad judge at all, but, Rozzi's filings is really calling it out that she's done some things that are not fair to his side. And no, it's not a game. This is, both sides should have, it should be a fair trial, and they're supposed to be out there telling the jury their side. And the judge is supposed to make sure that the laws are followed and both sides are treated right and the defendant's treated right. And, if that's in question, it needs to be put out just like he's doing. So, I don't know where we go from here. I don't know. I mean, what do you guys think of the stuff that dropped today? It's just, I mean, if it blew my mind last week, I'm just like, okay. Yeah. So, I don't know. I guess Rozzi's going to try to stay on, and I guess he'll potentially get another co-counsel, because I guess Baldwin's like, I'm not doing this anymore. And then we'll see if the judge stays on or if she's replaced. I don't know. I don't know at this point. Like I said, nothing surprises me, yet it surprises me in this case. But let's continue to remember and think that this is the reason we're all in this, because we want to get justice for Libby and Abby. That's what it's all about. Justice for these two girls. And that's what I'm here for, to report on. But again, let me know what you think of all this insanity that's going on throughout the courts with this case. And my hearts go out to the Patties and to the Williams and all these families, because wow, I mean, this is hard enough for them without all this. Alright guys, that's all I've got for this one. I hope you have a great rest of the day. And most of all, stay safe.